Welcome to this fine afternoon. So glad to see a little bit of rain going on outside. We'll go ahead and get the day started here with a hearing on Senate Bill 420 and ask Natalie to give us an overview.
Thank you, Mr. Chairman. Senate Bill 420 eliminates the element of concealment from the crime of breach of privacy, specifically related to installing or using a device to photograph or record another identifiable person under or through the clothing being worn by that other person or another identifiable person who is nude or in a state of undress. The bill amends KSA 216101. That's the crime of breach of privacy. Current law there provides that one of the ways of committing that crime is knowingly and without lawful authority installing or using a concealed camcorder, motion picture camera, or photographic camera of any type to secretly videotape, film, photograph, or record by electronic or other means another identifiable person under or through the clothing being worn by that person or another identifiable person who is nude or in a state of undress for the purpose of viewing the body of or the undergarments worn by that other person without the consent or knowledge of that other person with the intent to invade the privacy of that other person under circumstances in which that other person had a reasonable expectation of privacy. So a lot there. And this bill would remove two words, which are concealed and secretly. And those are underlined in the definition there in our brief so that you can read it without those words. And I can take any questions.
All right, committee questions for Natalie. Yep, Representative Eric Smith.
What did we hear on this last year? On this subject matter? We had a room full of folks testifying about a dressing room incident.
Mr. Chairman, I'd have to, I remember a couple of years ago, we added something related to that, and I can try to find whether that was in, I think it was in breach of privacy, but I'll look that bill up while you guys are taking testimony and let you know.
Excellent, thank you very much. I was thinking the same thing, couldn't remember whether we passed it or what ended up happening there. Committee, additional questions? Seeing none, thank you very much, Natalie. We will move into our proponent testimony. We have Tim Leisman, Wabunsee County Attorney, Kansas County and District Attorneys Association. Tim, welcome to committee.
Greetings, Chair Owens and members of the committee. My name is Tim Leisman. I'm the Wabunsee County Attorney, and thank you for allowing me to come today to speak on KSA 21-6101. We're, of course, asking you to remove two words from the statute, the words concealed and secretly. And we believe that doing so will advance this bill into modern times, more or less, and account for some technological advancements and adaptations. For example, imagine you're on a second story of a home in a bedroom, and there's a drone outside your window recording you. We know drones have video cameras. Is that concealed? Is that secret? No. But is that a breach of privacy? Of course it is. But it may not fit in our statute. Also consider we have a lot of short-term rentals, they're called now, or bed and breakfasts. You know, every room's got a bed in it. And imagine you're in, say, the office, and there's a remote workstation, looks like a speaker, but it's got a camera embedded in it. Well, it's not secret, it's not concealed, it's made that way. And it's plausibly supposed to be there because it's an office, but it could be used for nefarious activity. And the fact that it's out in the open could be a defense to a statute like this. So that's what we're trying to do. We're trying to bring things forward, account for situations that maybe we haven't seen a lot of in the past, such as drone activity or increase in short-term rentals. There was a case in 2020, a Court of Appeals case, where an individual who was found guilty of this had been recording an individual in her bedroom through a window, and he was using an iPhone, a mobile phone, which of course most of us have, and most of them have high-quality cameras and videos. And his defense upon appeal was, hey, this isn't concealed. It's not concealed. Now, thankfully, the Court of Appeals said, we think the jury had enough information. We think the jury could have found that because it was dark out and the positioning of his body, that he was in fact concealed. But that, of course, begs the question, What if he were just bolder? What if it was daylight out? Would that have been a defense to a crime like this? And the answer is very possibly. So that's what we're looking at, trying to, again, account for some of these situations. And I think I've got some colleagues that might speak on some of these bold voyeurs here in a little bit, so I'll leave that to them. But I'll leave you with, I had a case like this, and it was a good case. It fit the statute nicely. But as all cases go sometimes, it takes a little while, and that's what allowed me to think about this. It was a case where an individual actually used a fake smoke detector with a camera and was spying on their tenant, a long-term tenant. Tenant discovered the camera, called law enforcement, and they sort of flipped the script a little bit. The tenant got her own camera set up to look at the landlord when he came back in the home, which he did. And we were, of course, looking for some kind of reaction when he was trying to retrieve his camera to show this wasn't an accident. He didn't just click the wrong button on Amazon and get a camera instead of a smoke detector. And it turned out to be a very good case for us. He came back, he clenched his fist, you could see him mouthing swear words, he stomped all around, ended up being a good case. But during that process, I got to see the impact that these kinds of scenarios have on victims. And it does impact them, and it's of course hard to watch and see somebody go through that when their privacy is invaded like this. So that's what got me thinking about this, and I hope you consider that when you're looking at this bill, and we'd ask you to remove those two words. That's all I have.
Very good. Thank you, sir. Committee questions for Tim? All right, not seeing any. Thank you very much, sir. We'll move on to Jan Jarman on behalf of the City of Wichita, who I believe is joining us via WebEx. Are you with us, Jan?
I am. I'm trying to start my video. Can you hear me?
We can hear you just fine, just can't see you.
Well, if I don't get the video started, I'll just speak.
That's all right.
Well, shoot. Okay, I do apologize. The video is not turning on. My name is Jan Jarman. Thank you, Mr. Chair and committee. My name is Jan Jarman. I'm an assistant city attorney with the City of Wichita. I've been here about 25 years. I come before you today because the City of Wichita, we believe that a person should not be videotaped without their permission when they're in the state of undress. And unfortunately, the statute as written does give some leeway in cases that we've seen. I'll give you an example, and that is in just last year, we had a couple different examples. And one was, there was a woman who was shopping, I think it was like at a TJ Maxx, and she had leaned down to look at an item low to the ground. And there was a man who took his cell phone and slid it under the rack of clothing to videotape her up her skirt. The phone was in the aisle for everyone to see, but she didn't realize it was happening until it was brought to her attention afterward by the store manager. They looked the video up on the store and found proof that it had happened. They were able to identify the person, but unfortunately, because the video camera was not concealed, it was a case that we felt could not go forward because of the way the statute read. So that's just one example. We have multiple examples every year. We know that other cities near us have experienced the same problems. Derby also has experienced the same problem where we've had to tell victims that there wasn't anything we could do for them because of the exception that is in the law as it currently reads. Removing the word conceal and secretly, you still have, all it does is makes it still illegal. It will make it illegal to tape someone without their permission when they're in a state of undress. And we think that that would offer good protection to people of Kansas. So we hope that you'll move this forward, and I stand open for questions. I'm very sorry about the video issue.
You're quite all right. Thank you very much, Jan. Committee, any questions? Representative Mon.
Not really a question. I just wanted to thank my friend Jan for being with the committee today. I haven't seen her for a while. So
It is great to see you, Representative. Nice to hear from you. Thank you.
Well, and unfortunately, you don't get to see her. But she probably gets to see you. So anyway, thank you very much, Jan. We'll now hear from Lieutenant Aaron Moses, Wichita Police Department, who's also joining us on WebEx.
I am. Can you hear me?
Can hear you well. Thank you.
Yeah, I'm getting a message that the host or co-host has turned off the start video option for the meeting. So I don't know that you'll be able to see me either. But I will share my testimony by voice if that's okay.
Yeah, go right ahead and we'll have him look into that. Are you checking into that, sir? Okay, very good. He's going to check into that, but you can go ahead and proceed, Lieutenant.
Thank you, sir. I appreciate the opportunity to testify on behalf of the Wichita Police Department regarding this bill. The department strongly supports the proposed changes outlined. The current statute, KSA 2160-101, has proven effective in prosecuting cases involving concealed cameras. However, our investigators have encountered instances where the requirement for the camera to be concealed or secret hindered the progress of investigations. In May of 2023, our officers responded to an incident at a restaurant involving the inappropriate use of a cell phone by a male employee to photograph two coworkers under their skirts without their consent. The victims were two unsuspecting 20-year-old female employees. One victim did not even know that the photographs were taken until they were told by management later. The other victim was made aware by hearing a rumor from other coworkers. Despite gathering evidence, including surveillance video capturing the acts, the case could not be prosecuted under KSA 2160-101, as the phone that was used was not concealed. This specific case underscores the limitations of the existing law, leaving victims and law enforcement without options to hold suspects accountable for their actions. Our sex crimes investigators have identified several similar cases where victims were unable to hold suspects accountable due to the current language of the law. To address these concerns, the Wichita Police Department strongly endorses amending KSA 2160-101 to include the act of photographing or videotaping a person in a state of undress without their permission, whether the camera is concealed or not. Thank you for considering the importance of the amendment and for allowing me to testify before the committee on behalf of the department.
Certainly. Thank you, Lieutenant. Committee, Representative Schlingensieben.
Thank you, Mr. Chair. So if I'm not in a state of undress and I'm standing in my third floor bedroom and a drone comes up to the window and takes photographs of me up there, is that not prosecutable?
I would certainly defer to the legal experts as far as what would be prosecuted under the statute. I know that we do have specific concerns related to the concealment of the camera and specific cases that we have seen not be prosecuted due to the lack of concealment.
Thank you all for your presentation. Maybe another conferee.
Yeah, we'll certainly ask. Tim, is that something you'd like to take a crack at?
And yes, sir, under the current way that it's worded, that would be problematic because it does require that the person be nude or in a state of partial undress. So, but I would argue at least we get one step closer to, common sense breach of privacies. And then that, of course, is a policy concern. What about those situations where people are being surreptitiously recorded, but they're in a state? Now, one thing that I would be looking at in a set of facts like that, sir, is it an attempt? Do we have an attempt? Potentially an overt act. We've got a bedroom, somebody's in there. That would be something as a prosecutor I would look at and think that we still may be able to do something on.
Very good. Representative Butler.
Thank you, Mr. Chair. And I'm not sure who to address this to, but is there any way that this could bleed over to, we have the nanny cams and where they're in teddy bears and homes and some of those things where maybe it's inadvertently could happen, but could this stuff, could it bleed over into that? That's just a thought.
Yeah, go right ahead.
So it's still a requirement that we have to show an intent. So if it's an accident, then they really are like in a case of a short-term rental where, this camera's on all the time, we didn't even think about it. Then it's just like any other case where we're looking at intent, and we as prosecutors have to prove beyond a reasonable doubt, which is an incredibly high standard. Just like in the instance I provided you in my case, which really is outside of what we're talking about today, but we still had that concern about intent. What if our guy had just clicked the buy now button, smoke detector pops up, he clicks buy now, it shows up, he puts it on the ceiling and walks away. how do we overcome that? And in our case, we took steps and did what prosecutors and police do. And in this case, a victim that helped us, we got extra evidence to prove the elements beyond a reasonable doubt, which we'd have to do in any of those scenarios.
Very good. Further questions, committee? All right. Seeing none, thank you very much, and thank you very much, Lieutenant. I didn't get a chance to thank you for coming online for us. Committee, there's also written-only proponent testimony from Ed Klump with our law enforcement associations, as well as Michelle McCormick with the Kansas Coalition Against Sexual and Domestic Violence. I don't see any neutral or opponent testimony, and seeing no one raising their hands as such. Oh, sure. Go ahead, Natalie has a follow-up.
Thank you, Mr. Chairman. Thanks to Jordan and Jillian, we were able to track down the bill that you guys were referencing. It actually was a few years ago now. It doesn't feel like it was that long ago. But in 2022, in Senate Bill 366, ultimately, that's the bill it ended up in. You guys added this cohort of offender to the Offender Registration Act. So now these people are required to register as sex offenders.
Got it. Okay, thank you for that, and thank you to Jillian and others who helped with that. If there's anything else, committee? All right, we'll close the hearing on SB 420. I will let you know, originally, the agenda that came out for next week had us not being here on Monday or Tuesday. We will be here Tuesday, but we still won't have a meeting on Monday. We got another bill in late, so we'll have a hearing on Tuesday and then probably plan on working bills on Wednesday and Thursday. So with that in mind, thank you all. We'll